Good afternoon to everybody here. First of all, very, very warm welcome again and all the very best for 2026. It's a pleasure to have you here back again in 2026 as well. And it's my pleasure and my honor today to introduce our very first guest in this year. His name is Professor Dr. Simon Gerdemann. And as you might learn from the name, he's German. So it's a little bit weird that the German speaks to an Austrian in English. But we do this with a very good reason, which is that we will be speaking about the AI Act and about the impact of the AI Act on the European economy. And obviously, this is of interest to German speakers, but not only to German speakers. So this is the main reason why we will do this in English. Excuse my poor English, but I hope that the obvious gain in transparency and also an impact might outweigh the negative side of this. Simon Gerdemann is an acting chair at the University of Göttingen in Lower Saxony. At the moment, he has a really outstandingly brilliant CV that you will find on the internet. I've linked to this, so I will not repeat everything that is said here. Just two minor points. First, his CV is quite closely related to the life and also the professional activities of Professor Dr. Gerald Spindler, whom many of you know and who passed away a few years ago, unfortunately, much too early. And the second point that I want to highlight is that he has been very active in different domains that are IT and IP related, but also and in particular when it comes to the law of whistleblowers and whistleblowing laws. That might also be of interest in addition to everything that we are going to say here in a few minutes. Last not least, he is an outstandingly brilliant lawyer. You can find that out by reading his CV. And he is a very active writer in the domain of artificial intelligence and law, including one opinion article that I read a few weeks ago, and that was very impressive to me. You can see it, if you watch this, you can see it now on the screen. It was an opinion article for NJW, which is the most important and most impactful German legal journal. And the headline of this is Digital Unsovereignty, Digitale Unsouveränität, and it deals with the AI Act, but in particular also with the most recent developments on the AI Act, which is the so-called Digital Omnibus package. Simon will certainly in a minute explain a little bit more in detail what we're talking about here. And I found this piece that I also put a link into the show notes outstandingly interesting for reasons that Simon will explain in a second. So it's a pleasure to have you here. Thank you so much for making yourself available so early in this year. And thank you to be willing to speak about such an important but also sensitive topic today. Simon, what is Digital Omnibus? What is this about? And what is the specific interest you have in this topic?
Thank you very much. And first of all, thank you very much for your very warm welcome. It's a true pleasure to be here with you. What the topic is about, what the AI Act is about, and the Digital Omnibus and AI as well, is of course artificial intelligence. So arguably the most influential technology that we are experiencing in this part of the 21st century. The idea of the AI Act, as well as its further iterations, which may come about, is basically to regulate technology which we don't fully understand yet, or the path of which we don't fully understand. But nonetheless, we see a couple of risks. The Commission has seen risks, but arguably most legal scholars and legislators will see certain risks associated with the use of AI. The problem, of course, being that the field of AI is highly volatile and incredibly fast paced. So we're trying to regulate something which is really a moving target and which is incredibly important. That one's for sure for our economy, especially in the future. So what the AI Act is trying to do is apply traditional regulatory mechanisms which we mainly know from product safety law, which may come as a surprise in the beginning, but when the Commission was faced with regulating AI, which was the political goal, they were kind of baffled in the beginning. What are we going to do? We don't really know what AI is. How are we going to know how to regulate it? But the one thing they came across is, well, the thing that it's most close to in nature is product safety law. So whether you're regulating how to make child's toys, for example. So the children don't swallow certain small parts or whatever safety regulated issues they may come across. It's kind of similar to what we want to try to do with AI. So we want to identify the use cases of AI which we would consider to be particularly risky and particularly relevant for human rights, for certain other issues, and then establish a framework on how safety controls and quality controls can actually apply. So that's what the AI Act is. So prohibiting certain use cases of AI, but that's a very, very narrow part of the AI Act. And the most important part of the AI Act, arguably, is the so-called high-risk AI systems. So the systems which the legislator and other players identify as particularly risky to human rights, to democracy, you name it, there's a couple of things in there. Um, and then set up a system of rules on how developers, but also the deployers, the ones who are using it, should handle AI, what kind of risk management system they should set up, etc. So that is basically, in a nutshell, what the AI Act is trying to do. Maybe one little tidbit as an addition. There are, of course, other things which the AI Act regulates, in particular so-called general purpose AI systems. So that is the system, the model layer behind systems like ChatGPT. However, the rules are kind of wishy-washy and problematic. Maybe we can dive into that a little more. But when it comes to high-risk AI systems, they're basically two different sets of classifiers when a system becomes a high-risk AI system. The first is rather self-explanatory. If you use an AI system within another product, which is already considered to be high risk, so children's toys or medical devices, very important field of application for AI. If you use that and certain conditions are met, then the AI itself is considered to be high risk. It's kind of clear, like if you use a surgical robot, for example, and surgery and any tools relating to surgery are already high risk under the medical device regulation. And if you then have the robot basically not going rogue, but going autonomous and doing its own surgical procedures, of course, the AI system itself will also be high risk, because if something goes wrong, we're dealing with a dead patient if things go really bad. And the other high-risk system is high-risk systems where the use case, the application, is in a very sensitive field. For example, what is considered to be high risk if you use biometrical identification, or even more hands-on if you use it in job-related purposes. For example, deciding which applicants might get the job or which employees will get promoted to the next position. If you leave that to AI, we kind of have a bad feeling if the technology decides it and there is no real recourse to see if the technology might be biased, and if we're just talking to the machine where we get a promotion or we get fired. So those are the cases where the AI Act is specifically nervous about, and that's why it's regulating those applications and those systems.
Yeah, so that's the AI Act in a nutshell, and some of the problems were already mentioned by you. One of them is the difference between systems and models, and the other one, which is in my view perhaps an even more fundamental problem, is whether the fundamental analogy that AI is something like a critical system that produces safety issues, so that safety regulation is the right paradigm, has also become already obvious by what you said so far, right? So in my view, I would very much appreciate comments from you on both aspects. The first of them is this really, is the paradigm correct? And the second is this differentiation between systems and models. Was that a good idea? But on top of everything that you said so far, and that was also part of my question, there's now an additional complexity layer coming because of this digital omnibus thing, right? So, which is also something worth being explained, perhaps as a starter, before we dig a little bit deeper into the details. So, as you wish, take whatever you want from this.
I'm trying to take all. Let's start with the omnibus. So the omnibus is basically a package proposed by the European Commission. So it's not law by any means as of yet, which basically it tries to do two things. The main thing which it claims to do, and it really tries to do in many ways, is simplifies and simplify and synergize the different digital acts and regulations we already have. So the problem with, or the challenge is that we have a lot of, as you know, a lot of activity of the legislator in different fields. It's DSA, DMA, Data Act, and so on and so forth. And that is all part of the digital agenda of the EU. But as it turns out, those acts are not very much good at the interplay of those acts is uncertain, and it causes a lot of red tape and administrative burdens that might be avoided. So the idea is really to simplify that, to make it sync a little bit better, and then to do it in a way that reduces unnecessary regulatory burden and creates legal clarity. One big issue that it's dealing with, and that's particularly contentious politically, is data protection. So we have this old data protection, quasi-old data protection laws, and the question is, how do they relate to new laws such as the AI Act? So, for example, we have a problem that on the one hand we do want to protect personal data, of course. On the other hand, if we want to develop AI and if we want to be competitive in the AI field, we need a lot of data because those systems are big data related, and some of it, if not very much of it, is personal data that we're going to use. So the big question is, how may these systems and models be trained on personal data? And the Omnibus tries to find a middle way to still protect personal data, but on the other hand, still allow for advancement in AI technology. So this is one big area, and the other is basically looking at things which haven't worked that well in the past, or where the Commission has changed its mind. So when it comes to AI, for example, and that's going into the second question, the model layer and the application layer. So maybe just explain that real quick. So the models, the big models we're talking about, the ones behind ChatGPT and everything, the GPT models and the Google models, those are the big systems which are trained with incredible amounts of data, those self-learning algorithms which are trying to come up with a system which many people, including the programmers themselves, don't really quite understand anymore because it's autonomous. They are trying to create what we would call the artificial intelligence. And those are the big things which are developed in Palo Alto and elsewhere. The application layer is using those general, algorithmic brains, if you like, to fulfill different tasks. That's the stuff we really interact with as users. So ChatGPT would be a chatbot based on the GPT engine, which is the model layer. The problem with this whole model layer, however, is that Europe, by and large, absolutely doesn't matter internationally. Yeah, we have some players like Mistral who is still playing a certain role, but it's pretty clear we can't compete with the US in particular and with China, because if you want to develop really, forceful models, you need big data and you need cheap energy. Those are the two things which are very much of important, the resource layer and the data layer, which you need, and we don't have both. We have neither, basically, in Europe. We don't have cheap energy, and we don't have easily accessible large sums of data, and those big tech players are much better at developing that. Maybe we'll change that in the future, but that's basically our model layer. The model layer is, as of now, under the control of the European Commission, meaning that the Commission is responsible of enforcing those model layer, those general purpose AI rules. However, those rules are kind of vague, and it could already be seen that they are not really working in some ways. So they're trying to self-regulate, to negotiate with these players, because obviously Elon Musk is not very keen with following detailed rules by the Commission when he's developing Grok. So that's kind of a more diplomatic layer, if you like. The application layer is the layer where Europe becomes more important, because we have great resources in Europe when it comes to specific applications, because we have industry data, like think the automotive sector, and huge other sectors with Siemens and whatnot, that can use the models to create specific applications which are use cases in the real world. And that's where where the IAC really has power, and that's where the IAC tries to focus on. So that is the general distinction between model layer, usually US and China, and application layer worldwide. In Europe as well, we do actually have quite a strong application layer economy, and it's evolving. We have startups and everything. So that was that. Please remind me what the third thing was.
Whether safety regulation is the right
Yeah.
paradigm or the right analogy.
That's the big question. So I would say, in defense of the Commission or the European legislator, it's might be the closest thing we have to regulate AI. I couldn't think of another either technology specific or non-technology specific set of regulations which you could basically just copy paste to create AI regulation. The problem, of course, is very much that. Does it make sense to regulate a new technology like AI with the old set of rules and principles we have developed for completely different things? So for the Commission, if you're an administrative worker, let's say, in the Commission drafting a law, of course, what they're trying to do is find something that is similar and then just adjust it, which is what they did with the AI Act. But as you have already alluded to, like, is AI really that simple, that's similar to children's toys, cars, medical devices, and everything? Arguably not really, or at least it's way more complicated. And the crucial thing now is we have used certain regulatory techniques which have worked well, somewhat well, in traditional physical products, but cause massive problems when we're talking about AI. So the key regulatory mechanism, which the EU has been using since the 80s, they call it the new legislative framework. So new in EU terms means 40 years. Is to say, well, if we're legislators and we're trying to think of making something safer, let's say children's toys, we don't really know all the details. We don't know which precise, sizes of toys could be swallowed by children, how firmly they need to be fixed to another toy, what kind of chemicals shouldn't be used. Those are very detailed questions. And if we as a legislator talk about it, we can't really do that. We don't have enough specialists. We don't have enough time. The field is evolving all the time, and the products that are being used. So those technical details, if we don't do that ourselves, who could we delegate it to? Who could actually regulate technical details, which then a producer could then look at these things very technically and say, okay, I'm going to design my product complying to this, to this, to this, to this, to this. So very technical, on the ground rules. And the solution they come up with it, why not let's do this, like, let that be done by the companies themselves, by the producers themselves, in a kind of regulated or led self-regulation. So you have specific bodies, so-called standardization bodies, where these companies and these fields come together and they discuss, based on an abstract set of rules and goals, which the legislator has given them, how will you specifically regulate it? So, for example, if the law says you may not use chemicals which, if children are licking the toy, which, fun fact, they do all the time, may cause any physical harm or any physical conditions. And then they would come up with, a list of chemicals and how you should apply them and so on and so forth. That's what the industry is doing themselves. And then the Commission would look at, the standards, which those standard bodies, Senelec, how they're called, what those private industry bodies actually have come up with to regulate this. This kind of worked apart from the obvious, democratic legitimacy questions that arise from it, that kind of worked with children's toys, water bikes, or whatever else is being, or elevators, whatever is being regulated. It worked because the industry which regulated, which set up these standards that could be applied, was in fact operating in Europe, and they had an interest to create a set of rules which fulfilled the goals of the legislator, but also worked for the industry. That is different when it comes to AI, because the big players, which are right now sitting in those standardization bodies, which actually have the knowledge and the money, the resources to influence those standards, how AI is practically developed, they don't sit in Europe for the most part. They are mostly in the US. So if you have big players like Google or Meta, Alphabet as Google, those guys have whole armies of specialists, which they have. They have local specialists as well, people who are basically making their money with developing standards, which have been doing that in other fields as well. And they are sitting in those standardization bodies and they are setting the actual ground rules on how to develop AI. And that's the core problem of this high-risk regulation, which we're facing right now, is yes, we do want to have European rules, and maybe we even hope for Brussels effect or whatever. But as a matter of fact, the precise rules are not made by the EU. They are made by the US, more specifically big tech US companies. There's no real way around it. And the Commission knew about it, or should have known it in the beginning, but they were like, maybe they're going to be nice enough and develop standards which are actually fair and equal and everything. As it turns out, not really. There are two problems they're facing. One is it takes way longer to develop AI standardization than in other fields. Why? Because we don't have them yet. If you're developing new standards for elevators, there would be old standards for elevators and you would know how to do it. But AI, yes, we have some ISO standards and everything, but it's very complicated to come up with new standards. So it takes a lot of time, which is the precise reason why the Omnibus, as it stands now, did something that, to my knowledge, the EU has never done before. They basically said, okay, we're going to delay the AI Act or the core principles of high-risk AI systems for another 2 years. So it was supposed to be in effect in August 2026. And now, since we don't have those standards yet, not one really working final standards apart from bits and pieces, they are saying, well, the AI Act is going to apply whenever US big tech companies have finished those standardizations, but no later than 2 years after the original date of application. So it would be in August 2028. That would be the final date they have. So basically, this is the weird thing, and that is where this whole piece on digital non-sovereignty came along, is like, okay, we're trying to do European AI rules. The people who are actually doing the rules, the standards, are US companies. And now, effectively, those companies, not all of them, there are European players as well in their standardization bodies. Those companies like Meta and Alphabet, they wish European law to apply, and what kind of specific rules that European law will actually entail. And that is a very, for lack of a better word, weird way of regulating things. If you want to have European values being respected, and if you want to have the European industry to be protected by those kind of standards, it's very weird to effectively delegate that to your greatest competitor. And as it turns out, for good or bad reasons, let it be nefarious reasons or whatever, those standards seem to be drafted in a way that very much benefits the big tech industry in the US and not so much benefits the not so big tech, the startup and medium-sized companies, which we typically have in the EU, specifically in the field of AI. And that's the problem we're facing right now.
Yeah, Simon, thank you. That was an excellent introduction into the problem and very, very convincing in every detail. Let me, however, perhaps stress one or two additional points that I find important. The first one is, I think there is a fundamental problem from the very beginning, which is if you have an elevator or a toy, you have specific expectations, such as that it doesn't explode, or that that it doesn't do any physical harm to the kid licking on it, and so on. You explained that brilliantly. But when it comes to the AI Act, it's not that clear what exactly is expected there. There are fundamental rights, security, safety, whatever, all different kinds of values. And it's very difficult already from the very beginning to understand what precisely the system is expected or not expected to do. And that becomes even more apparent when you look into this way how high-risk systems are regulated, because as you rightly mentioned, there's this product perspective, which is in Annex 1. So it's toys, elevators, and so on. And then there's this somehow fundamental rights perspective, which is in Annex 3, which is employment and justice systems and surveillance, etc. Right? And they do not necessarily evidently have the same perspective, right? So that makes it already, also from an academic point of view, I think it's very, very challenging to identify what precisely the high risk element in the high risk system, as it is described in the Act, is. So that's, in my view, already the first point. The second point is that was not really unforeseeable. So everybody who was dealing with this 2, 3, 4 years ago was, I think, going very much into this direction in their arguments, and still the Commission was very much pushing this, and the last Parliament was very much pushing this, and we ended up in a situation where we now have this piece of legislation, and before applying it, we already add up an additional layer of regulation on the non-yet applicable regulation, hoping that now at the very end, it will hopefully help European industry to become a little bit more competitive in this environment, and hoping that now at the very end, this piece of legislation becomes somehow impactful on the development, which is very optimistic because, as you rightly said, Elon Musk is not really very keen to discuss the DSA with Europe, and he's not very keen to discuss the AI Act with us either. So why should that work now by adding some additional rules and by delaying the impact and the application of the existing rules? So isn't that, in your view or in our view, just another attempt to fail?
Tough question. I think in some ways it is, in other ways it might not be. It really depends on how the Commission and other players will actually use it in the future. So I would agree with you that this outcome that we're having right now was absolutely foreseeable a couple of years ago when the AI Act was drafted, and it's kind of curious why the Commission thought this is going to work, because you could already see the writings on the walls. Then again, I do have a soft spot for the AI Act in the sense that, I mean, as you alluded to, the cliche is, America innovates, China replicates, the EU regulates. So you can make a lot of fun, and rightfully so in some way, that the EU is trying to regulate something which it doesn't yet understand, which doesn't yet fully exist, and where it doesn't play the major role globally. There is a certain power play you could be doing with this AI Act, because we don't have any specific set of AI rules in any other country yet. We do have a lot of conflicting rules in the US, interestingly. So some states are regulating this, others don't, and arguably it's better to have one set of rules than many of them. There might be a Brussels effect. Not the Brussels effect in the sense that people are copying it, like some countries have done with data protection laws. But most companies in the US and China probably won't be very keen on losing a market with, depending on how you count it, 300 million plus X customers, the EU market. And everybody has to apply with it, with this AI Act. The funny thing about it is it's not as easy to comply with this thing as it was with, say, data protection laws, because usually what US companies did was develop a system and then at the end of it, slap some data protection thingies on it, like cookie banners and whatever, and maybe leave out some additional functions, make the product a little worse, and then put it on the European market. With the AI Act, it's different. If you want to really comply with it, you have to comply with it cradle to the grave. So while you're designing the algorithms, technically, you should already be taking this into account and you should document it. And there might be a way that if we can't influence the model layer and the big applications in Europe, maybe by creating them themselves, maybe we can influence it by saying, okay, we have a certain market and consumer power. There are no other rules. Come on, apply with these rules, big tech companies, and to make it easier, apply with these and voluntarily apply them in their own country as well. Because if you don't comply with them from the very beginning, you might not be able to enter the European market. Whether that idea will work, this international reach of the AI Act, largely depends on how we will enforce it, whether we enforce it strictly, whether we use those risk assessment rules to maybe influence the model layer, because we say if the model layer is not transparent and doesn't comply with the rules, then the systems which are built on it wouldn't comply and couldn't be sold. So there might be actually some regulatory power we could use there. The problem again is, and you said that already, we're giving most of the power away right now to those American companies. And yes, AI is not the same as children's toys and elevators. It's very much different. There are a couple of core principles which relate to the NX1 and NX3, so the product safety related AI system and the application related AI system equally. And most of those rules, robustness and everything, really are product quality rules in the sense of the AI system should probably do its job. And if it doesn't work properly to a high standard, then we consider it to be risky. So for example, to make that a little more practical, if we're talking about an AI system which is used in the job market, for example, to distinguish between different applications and to rank applications of applicants and decide, or at least suggest who should get the job if you have like a huge stack of 1,000 applications or whatever. The big problem is that the system might have a bias. And that's a general problem of AI. AI is not smart, no matter what the big companies say. The whole reality AI has is the data it's being fed with. That data is more or less being, creates the world of this AI system, and then it will deduce its conclusions from it within the neural network and everything. So if, for example, you're training this system, say with data from, because you have it available from the 1950s to the late 1980s, about which kind of people, if you give them a job, will actually excel in a company. Then the system in the end, if you apply it to modern days, will usually create curious results. If you have 100 applicants, 50 of them female, 50 of them male, the top 10 applicants you'll be given will likely be all, or at least in the majority, male. Why? Because the system has learned from the past, the people who made it in the 60s and 70s in countries, for some explicable reasons, have always been men, or mostly been men, and not women. So it will identify the fact that someone is a man as one crucial indicator of being a high-performing employee. Now, we now know and knew back in the days that there might be some sexism and other things involved which have created those results. But if you blindly apply this thing, of course, there's a fundamental rights problem. If you apply as a woman and the AI system will tell you, okay, you're basically not qualified because we have seen in the past women don't really get into the top for whatever reasons, and this is a critical quality marker. Unfortunately, we won't consider you. So preventing these biases, which comes with a lot of algorithmic and technical things, so you actually can secure with some processes and benchmarks that your training data is bias-free, that the system runs a couple of safety rounds to actually identify if it has created biases themselves. You can try to actually deduce the factors that the system has made up for itself to detect whether someone is qualified or not. So it does make sense to have those rules. One would hope that the market would already produce systems which are good enough in this respect, but that's what the AI Act is trying to do. But now, as you've already said, that's what the problem is. If you're regulating or self-regulating an elevator, then I would say most companies who are developing elevators have a self-interest in developing safely, because if one comes crashing down, it would probably not be good for their reputation. And it's mostly technical questions, like, how strong, I have never constructed an elevator, so how strong the whole apparatus needs to be and everything, and what happens if there's a fire, blah, blah, blah. The questions which AI is facing, or AI regulation, is very much, in many fields, human rights centered, and considers questions which traditionally and rightfully legislators in a democratic system would decide because there are values attached to it. So, for example, if a system identifies having a CV without any big holes in it to be a big factor of ranking someone high in an application system, then you might consider that to be a reasonable way of assessing, at least in part, the quality of an employee. Not having worked for 2 years or something might, you lack training, maybe you don't catch up with the recent developments, etc. The problem is, again, if you're doing this, you're likely identifying women again, because practically who is mostly, stopping their careers to take care of all the children today, similar to what has been to 20, 30 years ago, women are not doing it. Not saying that it's good or bad, it's just the way it is. The question now, and that's a discretionary system, value-based question, is should the system be allowed to identify that marker or shouldn't it? Is it discrimination if we consider holds in a CV to be a problem? Or is it just a rational reason to distinguish between people, and yes, as a de facto problem, women will face it more often than not. But then again, there are always differences between genders and sexes. That's a question that the standardization will have to answer, or the application of the standardization at least. But that's not the kind of question we want to give private companies. That's the kind of question that democratic legislators and courts would be deciding, because of the question of value, and a very intricate one. And those kind of questions have not been an issue with traditional product safety laws, but they're very much an issue now with a multi-purpose technology like AI. And we're now giving that to companies, private companies, not to say they're all bad, but on top of that, we're not even giving it to European companies. We're giving it to American companies, and expect them to come up with rules which actually, follow European values and principles.
Yeah.
And that's a big leap of faith. And that's the kind of thing. And maybe one last thing to add there. Traditionally, due to some weird legal reasons, those standards still aren't subject to judicial review. The argument basically being, at least the traditional argument, the Court of European Justice saying, well, it's not European law, because European law is only your law passed by a European institution. And those private companies, much less the American ones, are not European institutions. So you're coming up with a system which has very low democratic legitimacy to begin with, and which is also shielded from judicial review, absurdly enough, because the courts say, and the Commission says, well, it's not a European institution. We de facto delegated legislative power to them, but they are not a legislative body, and so we can't review those standards if they actually do comply with the objectives and the rules those companies in those standardization bodies have been given. So there's a vast problems, and that's only touching some of the problems which are a consequence of taking product safety law and turning it into AI safety law.
Yeah, I very, very much agree. And I just want to add one point here, which is I think one of the things that I've been seeing when it comes to the development of AI, and in particular general purpose AI systems and models in the last years, is that law is seen just as one of many means of competition for those companies, right? So if it's a proper strategy to call for regulation, they call for regulation, and if it's not a proper strategy, they don't. And they, of course, they also change their position. And I consider it unbelievably naive to believe that those companies will sit together now and objectively develop standards that will objectively follow European values as they are put into the AI Act. So this is, I would bet everything I have on that. This is certainly not what's going to happen. But what is happening is that, of course, they have market interests, and they fight for their market interests in this competition in which they are at the moment. So I would really bet on, I would say that my perspective would be that within the next 1 or 2 years, we will see plenty of additional discussion about what or not these certifications should look like. And at the very end, we will have another layer of very, very complicated law that most likely, like any other complicated law layer, will support the position of the incumbent, because for the incumbent, it's always an advantage to have a very complicated legal situation as a starting point. So why
Absolutely.
and how should that help then help European industry? Also from a logical point of view, I don't get it, how that ever should support any small or startup in Europe.
That's you're absolutely on point. That's exactly what's happening right now. I
mm,
mean, I don't want to say that everything that happens again happens for nefarious purposes, but if you're looking at, you said rightfully said, those companies have own interests, and they
mm,
should have own interests. Why shouldn't they?
mm,
And the interests they have are basically two interests. One is very much understandable, scalability. So they
mm,
want those European rules to be rules which are very similar to already existing international/American rules. And that's exactly what's happening. What you can find that many of the things which are right now being standardized in those bodies are references to existing norms like ISO standards,
mm,
which are usually influenced by Americans. Weirdly enough, those rules the ISO has come up with somehow also fulfill the same criteria that the European I Act is setting, even though they have been developed before the I Act was even in place. Weird thing. The second thing is, as you said, they do have, which seems weird, but they do have a certain interest in increasing the regulatory burden.
mm,
Why? Because they themselves can't handle it. If you're a Microsoft or you're Google, and I've talked to people in the industry, they are basically like, yeah, it's not nice and it will increase cost, but basically bring it on. We
mm,
have enough people internally who will figure out how to comply with these things. Plus, it's easy to comply with things you've developed yourself, um,
mm,
and we'll be able to do it. But the small and medium-sized company, and much of what we're having in AI industry in Germany and Austria and many other European countries is a lot of smaller. You have like 5 or 6 people who are currently developing a system. 3 of them are programmers. One of them might be a business guy. One of them might be someone in marketing, as those startups are looking, or even if you're looking at bigger, medium-sized traditional family companies or something, um, they don't have the time or resources to influence those standardizations. Because if you take one of your 3 AI programmers out of the company to work more or less full-time or even half-time in standardization bodies to influence those standards in your interest or in the common interest of the European market, then you're losing a lot of money which you don't have. And that's why those companies don't do it. We do have a couple of European companies, especially the bigger ones, who are playing a role. But then again, it's very hard if you come into a standardization body and you're trying to openly talk about how those standards should look. And then there's one big player or a couple of big players who are saying, by the way, guys, we have this, I don't know, data governance rules in Article 10 or something. We have already prepared a 300-page
mm,
proposal for how we're going to deal it. It references about 140 different standards, which are already ISO standards. And we could basically adopt this thing. Why don't you come up with a different proposal or just do as we say? So, and then you're sitting there with 2 or 3 guys trying to figure out, first of all, how do I understand it? Then could there be a better way? Could there be an alternative thing? So whoever comes up with the first proposal is always has a higher bargaining power.
mm,
Um, and it does make sense in some cases, of course, to adopt standards which are already there. It's not always a bad thing. But if you have complex standards which cross-reference existing American influenced standards in a way that is very hard for small companies to comply with, and very likely not specifically geared towards what the AI Act is trying to achieve in terms of safety and so on and so forth. But
mm,
but it's just a mess of different complicated standards which tries to to achieve scalability of AI development and application. That's a huge problem. And that's one of the reasons why now the European Commission, which it really didn't want to do, says, okay, we have to delay this thing because those standards won't be ready next year, August 2026. They're very confusing. They're not done, and we don't really know how to influence them because the European Commission itself doesn't really have the competence to and the structure, the framework isn't meant for it either to actively influence those things. They do now have the AI office. The AI office is still building up. Not to diminish their work, they're doing a great job giving the resources they have, but those resources are very limited. There are
mm,
very few people working there, and the very, very good AI people, sorry, I'm not working for the European Union or any administration because they can make 20 times the money if they go to private companies or fund a company themselves, and arguably be more on the interesting forefront of AI developments. So you won't get the Uber AI cracks, and hence you won't be able to understand the standards. And it's very likely that they will just rubber stamp it, which they have done with other standardization as well, with other harmonized standards in other fields, basically saying, okay, this looks like it really did what we were telling them to do. We don't fully understand the details. Yeah, this is now the official standard. And that, of course, is a huge problem. Absolutely.
Yeah. But also the delay might become a problem, and also for not only for the SMEs, but also for the major European players. I mean, take Siemens or somebody like this. They do have a rather good track record in product safety and in complying with medical products legislation and all this. And suddenly they are confronted with a wave of disruption coming from non-European companies, changing the whole industry and stating, well, we do not really care too much whether your medical device is now safe in the sense of the European legislator, right? So I think we are really in a trap here. Delaying produces a problem, speeding it up produces a problem, and the European industry is losing in any case. So it's really a very, very dark outlook, probably. Which brings me to the question. So first, would you see some positive aspects that I'm not seeing here? And second, what should Europe do then now? Or what should the European legislator do now?
Well, I think when it comes to delaying the application of the AI Act, or the actual effect of the Act, we don't have another choice. We can't, apply the AI Act from August 2026 without having standards. Why? Because pretty much every company, European or not, will automatically violate the AI Act, because it's virtually impossible for most countries to comply with the extra abstract requirements of the AI Act and its annexes without having standards. Standards are made in product safety, and for better or worse, this is product safety law now, in product safety law, because if you're working as a technical expert in the industry, you need technical guidelines to really make your product conform with the regulation. So starting high risk regulation, at the very least in the new areas, these Annex 3 thingies, which are human rights centered, you can't let the AI Act high risk regulation go into effect without having any standards. But because that would create chaos. The only thing you could do is basically turn a blind eye to any violation and say, we know it's hard, you're not getting fined. And then tell every member state that let the people violate their law, we don't care. So
this
that's
is
not
what we see at the DSA, by the way, at the moment, right? So somehow,
exactly, just to some degree, that's what we're seeing in the DSA.
And also in GDPR in many ways, right? So they wouldn't be completely new, right?
Exactly, they wouldn't be new, but it would be particularly brazen. And the ones who are really trying to comply with laws, and there are good companies who are trying to do that, they would invest enormous amounts of money to comply with the law, while its competitors don't. And then they have a disadvantage. So that won't really work. Similar to the DSA, we could let something slide, but it really isn't an option. So we have to delay it. There's no way around it. For how long, and if we really want to, let the companies and the standardization bodies effectively have a say when those standards will apply bit by bit, different question. I think the important thing now becomes which part of the AI Act do actually seem sensible, and how are we going to enforce them, and how will we be able to enforce them in a way that protects European industry. And there are a couple of positive things in there, no doubt. So one positive thing, for example, is we do have or will eventually have a unified set of rules, while others have to work with all kinds of rules. And we can actually use the fact that a product will comply with the AI Act as a selling point on the market. So using that and saying, for the most part, those rules are really quality rules. Safety as well as quality go hand in hand. The AI should work well and not cause any problems. So if you have those European CE marking in the end, which will eventually come for high-risk systems, use it as a seal of quality. not only to market it in the EU, but abroad, and make companies, European application layer companies, make those the companies which are known for producing the best quality AI applications in the world. Similar to how we have done that with, other things which are originally not designed to be a market advantage, like produced in Germany, those kind of suites and that kind of stuff. That's one way. Then you have to have a spine, and have to be harsh in some way, and really, represent European interests when it comes to American companies. There's no way around it. If we just, bend over backwards to please American interests, no matter if it's the president or a particular company, this whole thing won't work. So you have to apply these rules in a way which is lenient in the sense that it doesn't stifle regulation, that it doesn't smother it, but at the same time harsh in the sense that whenever an international company is coming to us and selling their products, which they inevitably will be trying to do, they won't stop it entirely, definitely not. You got to apply it harshly and say, apply with our values, the same as our European companies are doing it as well. And maybe even particularly focus on the foreign big tech companies, whether it be from the US and China, to actually make sure that their risk assessment and everything is right. And then personally, I believe there's no really way around it that you have to reassert yourself and reassert democratic legitimacy into the standardization process. If you just let things go as they are at the moment, we might have standards. We certainly will have standards with respect to certain requirements. We might have standards by August 2028, but it really doesn't look like we have full standards by 2028. And then the question, right, is what are we going to do then? So you have to speed up the process and really make clear, come on, guys, we need those standards. And you have to really go into the weeds and go into the technical work, either as the Commission or as a collective of European companies, which are very hard to organize in this respect, but nonetheless, and really make sure those standards reflect European values and don't disadvantage European companies by favoring big tech American scalability interests. That's something that's unheard of in product safety law. As well as those standards being revised or being checked by laws, being actually subject to judicial review. That's another thing I believe is necessary. But we do have to recognize, as you've underlined as well, AI safety law, if we want to call it like that, is not like traditional product safety law. And one consequence we have to draw from that is that we need to be more active in the standardization process, and we can't just have foreign companies do the standardization as they please if we want to have an actual European framework of AI regulation in the end. Whether it is by 2026, 2027, 2028, I don't know. But the worst outcome would be if we finally have standards and those standards are an effective disadvantage for the European industry and don't protect individual rights in Europe, then the question really has to be asked, and the Commission has to be asked, what the hell were you doing here? So there's no way around it. It is hard. It's hard to get the to the AI office, to the experts. But we want it to work. There is no way around it, at least in my opinion.
Yeah,
and then
I agree. Yeah, Simon, I think I agree with almost everything that you're saying. There's just one little grain of salt that I still want to add into the wound, which is, how come that anybody would have the time and the resources to suddenly start to work on this reliably and consequently in standardization bodies? It won't be academics like you and me, because we have plenty of other things to do. It won't be industry startups, industry at least, because they, as you rightly mentioned, don't have the resources. It will be very difficult for European major industry to participate in this, because it's a completely different game that they were used to play. And in particular, the tempo in which all this is changing all the time is very different from what you normally have in normal product cycle regulation. And I don't think that it will be the Commission, because the Commission, and even if it were the Commission, probably the people doing that for the Commission wouldn't be the most suitable ones, because they wouldn't have the industry background needed for this. So I don't get it where your optimism comes from that this call will be heard by someone having sufficient impact in this.
Absolutely fair points. I don't have optimism or pessimism either way that something like this is going to happen. And there may be other ways to activate a little thumb screw. If you just increase the supervision and say at times we don't accept this, we don't accept that, without actually going too deep into the production. Would be framework which would absolutely work. So I agree with you. The AI office, despite the great work that many of them do there, won't be enough. They don't have the technical qualification to do it. The EU is trying to recruit people who are doing it, but most of them, as of now, are lawyers. And as much as we like the law, we're probably not the right people to, do the standardization on AI algorithms. You could do a public-private partnership, for example. You could say, as the AI office, okay, we need external experts. We take a very large sum of money, have some private entities set up, and we would actually get people from the industry. We would maybe get a couple of professors, and then give them funding for it. And we would really set up a panel of experts, not just NGOs, not saying they're not important, but really experts who require decent pay, and set them up and really, tell them you have a chance to influence the course of AI for the future, and you're being paid at least half decently compared to what you're currently making in an AI company somewhere. So that would be a way to get the expertise externally and then have them fed to the AI office and introduced into the standardization body. And there are other ways where you can subtly influence things. For example, you could reject a standard, something that to my knowledge has never really happened, at least not for those reasons. They were just rubber stamped. If you tell the people we're going to actually review the standards and we're going to subject them to the judicial review unless they really do what we say we want them to do, that would be completely new for the whole standardization world because they're very much used to working outside any control framework. Maybe that would help. I'm not saying it's optimism. I'm saying it will work in time to some degrees, and not all of it is value-based. They are just technical rules which they have to come up with, which Google will come up with just as any other expert, and it will be fine in the end. It's just quality control. But I'm not saying I'm optimistic or pessimistic. I say there are opportunities. The omnibus, as we have it, doesn't address these crucial issues. You have to be as harsh as that. The only thing it does say in relation to that is that it wants to expand the competences of the European Commission and the AI office. So, for example, they want the oversight over any AI system that's used on social media. Which is interesting because potentially any system can be used in social media, so they would have the theoretical competence for everything. But they don't know how to use those competences. Like under the DSA, not to go too far into another thing, but if you're looking at the DSA, for example, most of the enforcement, and some of that has been really good, but most of the enforcement was just going for the low-hanging fruits. Like the 120 million fine for X right now, they were looking at transparency obligations for the most part. What are transparency obligations? Something that is very easy to control, because if something's not transparent, then you already have a violation. So you don't need technical expert in the commission to actually check whether someone violates transparency obligations. What you would need technical experts for, and specifically if we're talking about AI on social media, which is becoming an increasingly important thing, you would need access to the algorithms and the data sets, and you will need people who are actually qualified to understand, analyze those sets and come up with rules that those algorithms have to meet. That doesn't exist yet, and it won't exist with the omnibus either, because the omnibus doesn't really change the rules. In fact, when it comes to social media, it might make a few things even worse. Yeah, we're definitely having big challenges. I'm not one of those people who says don't regulate AI. I think it's absolutely right that we should look at regulating this. But the way the path dependence, the path that we have gone down now, causes inevitable problems which are not yet properly addressed, and much of it we won't be able to fix by just adding 2 words to a legislation. We need actually competent experts and a clear roadmap on what we want to do to protect our own interest and what we want to do to make sure that just because the Americans have the huge data centers and are usually on the forefront of technical development, that they can actually use those advantages to disadvantage European companies and to have an influence on our societies, which is far beyond anything we would like to tolerate in a democratic system. Will they do it? I don't know. The European Parliament is quite active right now when it comes to the Omnibus package. They are dissatisfied with a couple of things. Maybe they will tackle those issues. As of now, the answer has usually been, take the legislative burden down and increase the competence of the Commission. Not saying that's wrong, not saying that's good. I'm just saying that's the usual answer, at least when it comes to increasing the competences that the EU level always has. More competence is always great. The question is what you're going to do with it, and is this going to help? And in the field of AI, I agree with you. It's not exactly where it should be right now, and there are challenges which are not being tackled either by the legislator or by the administrative authorities.
Thank you so very, very much, Simon. I think this is a wonderful final statement for today, but I do hope that we continue this conversation when we know a little bit more about what the Parliament is really doing, because that's also one of the very many unclear things at the moment, how the Council and the Parliament will really deal with this and how long it will take. So I hope that we continue this discussion then when we see a little bit more on this. For today, thank you so very, very much for giving us so much of an insight about what you think and what you write about. I appreciated this a lot. And to the audience, thank you very much for being with us. I hope that we will stay in touch and that all of us keep being as healthy as possible, or becoming as healthy as possible, as quickly as possible. All the very best for 2026 again, and hope to hear from you soon. Bye-bye.
Thank you very much. It was a great pleasure to be here.
Thank you.